three words: transformative, equality, and tension. The three words which came out in his talk. It's which one? This one? Thank you. Oh, it's the one. Well, I don't know. Structure what I want to say. There are various ways of explaining transformation, and I want to focus on one of at least three ways that make sense to me. One is political transformation, and there are people in this room who can speak much more clearly and much more self-consciously about the processes that went into the UN Convention. There is also participatory transformation, which Joe Quinn also mentioned, that is to say the participation of persons with disabilities in this process, which was transformative as well. But there's a third level, and that is normative transformation. And what Jerry has asked me to look at are, if you like, the opening salvo, the normative salvo of the convention, Articles 1, 3, and 5. And to look at them to draw out the values, the norms, the very basic underlying premises of this convention, and to do so in a way which explains the transformation, the transformative nature of this convention. But what I want to do, because I'm pernicious and evil, and I have background in philosophy, although I'm a lawyer, is to show you the tensions that these values create and why it is that normative negotiation is essential. What is brilliant about the way Jer has set things out is that the tensions that we'll be exploring this week involve, among other things, the difference between immediate and progressive, the difference between what aspect of human rights, the humanity of rights, is something which is instantaneously recognizable, in the absence of which there is a violation of the most basic understandings of human dignity, versus other things which need, because of limitations in resources and conflicting rights from other directions, that need to be negotiated. These are problems which are real, sometimes very concrete, and not trivial. So what I want to impress upon you is the difficulty of these value conflicts, which in some ways sound churlish. I'd love to see that word up there. Churlish. Exactly right. By churlish, I mean the disability rights movement has been the most productive and valuable force in the recent history in human rights generally and the condition of persons of various forms of disadvantage particularly. There is a tendency, however, to find a level of uncompromising direction in advocacy. The advocacy has been productive of the UNCRPD. The convention has been produced. Now, the theme of this week is making it work. Making it work is a process of negotiation and compromise. And it's going to be compromise at the tensions, or among the tensions, that I want to highlight in the values, the core concepts, the core values in the convention. So my progress is, in terms of this list, I want to do a kind of fantasia on the key terms in 1, 3, and 5, and to show you some of their interrelationships. This is at a low, conceptually basic level, but it's worth it. Focusing on equality, because that is usually where all of this ends up, and then look at three subsidiary but very important issues. One, what the phrase the human rights approach means, what it means to say that human rights are universal, and lastly, the bane of my existence, the paradigm shift. I have rejected the term paradigm shift since it was brought into the scene. Certainly, as Rosemary, and I think we agree on this completely, that it is new. I mean, there has been at least 60 years of the development of this so-called instantaneous paradigm shift. And I'm not going to spend a great deal of time, but I will show you what a real paradigm shift is and whether our transformation here constitutes a paradigm shift. A confession. Now this may change your entire view of what I'm going to do. I'm talking about values. I'm talking about normative values of a very, very general sort. There are usually two approaches to values, and I'm calling them realism and idealism. Realists, like the critical legal studies people that are in the background of much of what Jer is writing, think, well, values are subjective. They're really empty vessels that we can pour what we mean into them, and the issue underlying it is not values, not morality, it's power. What you need to do is seize the power. If you're a disadvantaged group, you seize the power, and then you use these words to describe your progress. There's nothing underlying them. There is no objectivity, for heaven's sake, to values. They're mere puffs of expression. Underlying it is power. I'm a realist. An idealist is someone that believes, idealistically, Pollyannishly, foolishly, that people of good faith with patience and intelligence can give meaning to values, can look at equality and say, that's not just a word with nothing in it, it's a complex word that can actually mean something. And by doing so, and if you're actually a true idealist, only by doing so can you actually do good in the world. That's my confession. Everything I'm going to say from now on is based on the view that values like equality, like human dignity, are not subterfuges for underlying shifts in power, but are actually meaningful concepts. Call me foolish. Call me idealistic. But that's how I want to present it. The three articles I want to look at are one, and I'm just going to flash through them because I want to be a lawyer for a while and dissect them in terms of their underlying language. The general principles, Article 3, and Article 5, equality and non-discrimination. So for the next 15, 20 minutes, I want to dissect these as a lawyer would, to parse them out, to extract values in them, and to show you what this fantastically well-crafted piece of legislation, this treaty, has managed to do with these values in a way which will direct, whether you know it or not, whether you appreciate it or not, all of the legal work, all of the thinking that you could do from this point on. So a little bit of lawyer parsing of language. Article 1 actually has two parts to it, and it looks like this. The first part is a declaration of universality with respect to human rights and fundamental freedoms, pointing to the central and the most vague, to be perfectly honest, value, inherent dignity. But interestingly enough, the second part of that presents actually a theory of disability. The second part of Article 1 is a way of conceptualizing disability, certainly not new, certainly has been in literature for a long time, that is embodied in this document. And the conceptualization goes by various names: social model, relational model, environmental model, interactional model, but it all comes to the same thing. Disability is an outcome of a complex interaction between features of the person, which we, for sake of argument, can call impairments, and something in the environment, and by environment I mean the physical environment, the human-built environment, the social environment, the cultural environment, the linguistic environment, the attitudinal environment, where we live, the ambiance of our lives, how all of us are contextualized. Something in the interaction between a paralysis of sensory impairment, a cognitive impairment, between something that is, if you like, residing in the human body and the world. In that interaction, disability arises. Disability is neither inevitable nor basic, fundamental to the physics of the world. It is created by neglect. It is created by the absence of accommodation. It is created by features of the world that may be difficult to change, but are changeable. Disability, if you like, is allowed to occur by the failure to provide assistive technology, by the failure to accommodate buildings, by failures in human structural organization. Impairments are in the domain of God, if you wish. We can change those too. We can ameliorate them. Pain can be diffused. Spasticity can be relieved. Joints can be made to move more flexibly. But disability is where those things interact with the context in which we live. Well, what's the relationship between 1 and 2? What is the relationship between a declaration of rights and individual inherent dignity and what disability is? These rights focus on barriers. The understanding of disability is that as an act of human quiescence or actual directed intention, impairments are transformed into disabilities. And that, at the end of the day, is a violation of human rights. So Article 1 brings the phenomena of disability and the phenomena of rights together. It links the reality of disability with the normative claim about what brings disability about. So that is how the structure of 1. First tension. Does Article 1 speak to impairments? In the disability movement, there has always been a reluctance to suggest that interventions such as prevention of impairment, interventions such as arranging public health services so that, for example, in Africa, river blindness is prevented through various interventions, public health interventions, whether this is part of the human rights tradition in disability, preventing impairments. It is a conundrum, it's a question mark, it's a tension. Certainly one of the features of the so-called medical model, its excesses, its insanity really, was that the only intervention relevant was an intervention at the level of impairment. You take care of impairments, you cure them, and it's all gone. Disability disappears as a phenomena. Well, we know perfectly well that in fact disability will not be disappeared from the absence of impairment because, as lawyers, we know that it's not the impairment that causes disability, it is the perception of impairment that causes disability. Discrimination is a person's reaction to the perception that someone is different, and that impairment may not exist. In fact, for that perception to motivate the discrimination. So as lawyers, we don't think there's a necessity for the impairment, but the question is, and it's an open question, put it in concrete terms, is it a violation of the human rights of people with disabilities to have mandatory seatbelts? Is it a violation to create new people with disabilities, to prevent their existence by insisting on wearing seatbelts that prevent the kind of damage that is done in an automobile accident? It is possible to make the argument that preventing people from disability to be created is a violation of their rights. It is an argument I have heard. It is an argument which raises tensions, and I want you to think about. It is not an argument which I'm going to address, but it involves that second yellow arrow, the question whether human rights applies to impairments alone, as well as barriers. Okay, Article 3 contains lots of interesting words, and sorry, I just have time. I'm going to eliminate the two bottom clauses, which are equality between men and women and respect for the developing capacities of children, and focus on the six very, very meaty, or as a vegetarian I would say very tofu-filled ideas that really constitute the normative structure. And I'm going to highlight those. And I want to do a little trick, a little lawyer's trick, and I want to clump them in interesting ways because I think they're clumpable. I think they can be brought together. And what I'm going to do is just bring inherent dignity, individual autonomy, and respect for difference under one clump. And I don't know what I want to call this clump, maybe the dignity clump, whatever. And besides, this is just me. If you think, this is rubbish, I would do it different, it's up to you. I see these as forming an interactive complex because dignity and autonomy go together extremely well. Autonomy is the allowance to make determination of how one is going to live one's life, which is either constructive or productive of dignity, or dignity demands it as a precondition. Respect for difference in the context of disability is that dignity cannot be undermined by mere difference. The fact of difference is a celebration of human variation. It is not the proper cause of disrespect. So I find these to be in an interactive whole. Well, I have no problem with clumping these two, non-discrimination and equality of opportunity. I have no problem doing so because that's Article 5. Article 5 itself brings together equality and non-discrimination, and once again, just to make life slightly more simple, I'm going to get rid of the so-called reverse discrimination provision and just look at these three components. Now, what's interesting about these components is we have, once again, a general claim about equality, the universality of equality, and then two interesting legal requirements for the facilitation of equality. But first, a patriotic footnote. For the three Canadians in the room, of which I am one, I would like to direct your attention to the following piece of textual similarity. Equal before and under the law and are entitled without discrimination to the equal protection and equal benefit of the law, CRPD Article 5, looks very much like Section 15(1) of the Canadian Charter of Rights and Freedoms, except the Canadian is more grammatically correct. I'm sure of it. Every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination. Oh, Canada. Thank you, thank you, thank you. Going back to Article 5, actually New Zealand picked the language of Section 15 of the Canadian Charter verbatim without changing it at all, which gives credit to the Canadian drafters, of which Michael and I know some, I think, from that era. Back to Article 5 and these three provisions, because of all the provisions in the convention, these are, if you like, the most at the core of what a convention, what the values of the convention represent. But I want to, as a lawyer, I want to bring your attention to an interesting little feature of this, and it's a feature which is going to haunt the interpretation of the convention, I can guarantee it. And that is the phrase equality of opportunity under Article 3. The issue, Article 3 has the phrase, and I'm not going to be criticizing this, I'm just, as a lawyer, I wasn't involved in the drafting, and I'm a lawyer. I'm looking at this document saying, here I am, I'm going to be in a courtroom. What can I do with this language? Can I go this way or that way? Notice this fact. Equality of opportunity, which has had a long political history, in Article 3, and this long and convoluted phrase, stolen from the Canadian Constitution, Article 5, the question is that what equality of opportunity is supposed contextually within the convention to mean? Is equality of opportunity supposed to be this four-part equality? Indeed, it has four parts if you read it: equal before, equal under, and the law, and entitled without discrimination, equal protection, and equal benefit. We have four components there, four equals. Now, an open question is whether equality of opportunity is to be read down, as lawyers say, to be read down in terms of those four very legalistic forms of equality, or whether politically equality is to be understood more in terms of redistributive equality or redistributive justice. These equalities are legalistic in the simple sense that they require equal before and under law could in fact be a form of what is usually called formal justice. That simply means legal standing. Everyone has legal standing to bring a case before a judge. So formalistic in the sense that it is procedural. Equal protection, equal benefit of the law has often, certainly in the Canadian context, been interpreted as substantive in the sense that people are, if there is a program in healthcare or a program in education that is available to people, then it is the protection and the benefit is equally distributed across populations without prejudice, without discrimination based on enumerated grounds, or disability in our case. So the complex four-part equality has been interpreted, and there's an incredible amount of jurisdictions on that, jurisdictional information on that. And I would imagine that lawyers looking at that phrase will have at their benefit that kind of understanding. But my question is a different one. Is that equality of opportunity? And if it is, does that limit the potential change that the convention can create? Why am I emphasizing this? Well, Chairman Quinn told us that a transformational treaty does not change process alone, but changes substance. In our cultures, changing substance means redistributing resources, reallocating resources, a reasonable accommodation as a reallocation of resources, some version of income distribution, whatever, some change in the way resources are managed by the culture. If that is what is required for an effective transformative convention, then I don't think the language in Article 5 is sufficient, and I know equality of opportunity is insufficient. I'll show you in a second. But back to my chart. How about the last two? The last two are simple. Accessibility and participation and inclusion, well, that's easy. Accessibility is a means toward participation and inclusion, so their relationship is actually causal. Accessibility is making the world usable by the widest spectrum of abilities that are represented by the human population. Making buildings accessible means, among other things, that buildings can be used by the largest number of people representing the widest spectrum of abilities. Well, that increases participation. In fact, that makes participation possible. But as it happens, accessibility is also important, also a precondition for equality and for inherent dignity. So what we find in these relationships is a possibility for a secure relationship that enables us to do a table, and tables are always useful, aren't they? What I want to do is look, and just as a way of conceptualizing the values in the convention, look at them in terms of whether they are means to something good, instruments to something good, or goods themselves. Because that will mean, among other things, that we can imprint things which are valuable as instruments onto processes, onto administrative arrangements, and put the things which are ends, map them onto outcomes of processes and administrative procedures. Well, accessibility is a means. We've gotten that one done, and we've just said that participation is the end. Respect could not possibly be a means. It is obviously an outcome. It is what you're striving for, and the problem with that is, in a sense, that participation is also a means to that end. Because if you participate, your level of respect increases. So, unfortunately, participation, maybe not unfortunately, is actually both a means and an ends. Well, the same has to be true for respect, because the more respect you have, the more likely you'll participate. So respect, too, is both a means and an ends. How about equality? Now, that one's easy, so to speak, because we know that non-discrimination, reasonable accommodation is not an end in itself. It's a means to equality, and that equality is that end. So this little diagram gives us a template for a series of arguments, if one were to be interested in pursuing them. Namely, to argue for the accessibility as an outcome is to misunderstand what accessibility is as a normative statement. Accessibility's value is completely absorbed by its instrumentality. It is valuable only for what it achieves, not what it is. That means that sinking money into non-productive accessibility, wasting money into building accommodations that don't have an end of participation, is a failure to represent the value which accessibility is. One could build out of this picture a series of arguments of that sort, but I'm not going to spend much time with that. I want to go back to this point. When you're looking at equality, equality in political philosophy terms is the most complex normative value. It is, its level of interpretation is, it boggles the mind in its complexity. To say that we are just here to achieve equality is to use a phrase that can be interpreted in so many different ways that it is almost useless to speak in those terms. There are many accounts of equality, but I'm going to divide those accounts into two because that's the only set that is useful in this context. Equality of opportunity, as the word suggests, means that those barriers which prevent you from utilizing your resources in a way to achieve your end has been diminished, and equality of opportunity is secure when those barriers are removed. Equality of outcome is an account which says only when the results of the way society is arranged are equal. Equality of resources, equality of happiness, equality of all the good things in life, then you have equality. Equality of outcome is obviously the most powerful, extreme, if you like, radical sense of equality we have, and it has this feature to it, which is relevant to the Convention's application. It is never-ending. It is not an episode that is secured and then the government's obligation is removed. It has to be monitored and constantly updated. If you're looking at outcomes, outcomes are longitudinal. They change over time. So what is the equality in Article 5? What is the dominant theory of equality in the Convention? If it were pure equality of opportunity, sometimes called formal equality or sometimes also called negative freedom, we would have an account of equality that is so weak as to be unusable. Imagine, for example, that life consisted of a race, and the race had 5 contestants. This is a foot race I'm thinking of as an analogy here. And because of birth, the accident of birth, because of inherent wealth or whatever, some people start before the starting line and some people start ahead of the starting line. You fire the gun and the people who are closer tend to win. Think here of people like Romney, for example, comes to mind. No, never mind. No politics. So what does equality of opportunity suggest? Well, everyone starts at the same place. Fine? All these artificial restrictions, like privileges or detriments, people start at the same line. And off they go. The winner is the fastest. Well, the problem with that is that some people will lose. And in the race of life, losing means starving to death. It doesn't mean not getting an award. It means that you don't have enough to live on. That's what losing means. So that form of equality is perfectly equivalent with starvation. There is a great quote in Immanuel Kant's Critique of Pure Reason, which no one reads, but there are good footnotes occasionally. Kant had a sense of humor, believe it or not, and in this footnote he says he comes upon a land which he's never been to before, and he takes the carriage into town, and he says, he sees beggars in the street, and he says, a civilized country. Because he knows that in that country, people who don't have talents fail. People who don't have the ability to succeed starve to death. And that means it's an equal country. That means political equality has been secured in the sense of equality of opportunity. Now, Kant may have been joking, it's hard to say, but he's right. This sense of equality of opportunity is a sense in which artificial restraints are removed, but everything else, say, the inability to walk, is not compensated for. This is, you're given the opportunity to win or lose. The response to that in political terms, is equality of outcome, which is to say the aim here is to get people well-nourished, have to be able to achieve what they want to achieve, to give them jobs and the rest of it, and you're getting a hint of social democracy and welfare and various other kinds of late liberal programming, all of which are motivated by the view that allowing the race to be fair does not guarantee equal outcomes. What does the convention view of equality? I want to make a suggestion, and it's open to, it's just my suggestion. There's an understanding of equality of opportunity that is far stronger than the formal one, far more robust, and I think central to the underlying premises of the convention, although it would take a book to make that case. It goes by, it's a product of Nobel Prize-winning economist Amartya Sen, and whose work is impenetrably difficult to read, but is extremely influential. He calls it capability. It's equality of opportunity understood as capability. And what capability is not the intrinsic abilities of people to do things. It is the provision of all that is required for a person to achieve what they want to achieve if they wish to achieve it. As Sen puts it, it is the ability to be or to do whatever you choose. Now, capability obviously requires negative freedom. All the barriers have to be removed, but here's the trick. The things that you need in order to do or be what you wish are provided. So it is an example of what's sometimes called positive freedom. Now that sense of equality of opportunity is strong enough, I think, for the convention, and it's a proposition I'm suggesting is the appropriate interpretation. Is an interpretation of the convention that would give it life. Why do I think this? Well, there is two chunks of textual evidence. One we've seen in Article 5. There's another phrase which is suffused. It is all through the convention. It is a phrase that explains the comparative standard of equality, or at least that is what a lawyer could argue. Equality on an equal basis as others. That phrase prevents the equality in the convention from being equality of outcome. Intentionally, unintentionally, that phrase means that the strongest equality can be in the convention is what I'm calling capability. Because on the equal basis as others means to be situated, at the least, situated in a circumstance which is not prejudicial to you by virtue of the way you're treated. Not everyone succeeds. Not everyone achieves what they want to achieve, and people with disabilities are to be compared with those people. That is the interpretation of the convention that I think is possible, and that one is compatible with equality of opportunity, I think, in the strongest version. Okay, that's it. That wasn't so hard, was it? I mean, that is I mean, if I'm right, I've highlighted the core concepts, the value concepts, and ending with equality as one should, and the kind of tensions that are involved. The tensions are, is the convention a redistributive document? Does the convention require money to be sent from one package to another? That's the bottom line here. Equality of outcome, you bet. You can't do it otherwise. Equality of opportunity in the weak sense, never redistribution. Never. Because the only thing you remove are artificial barriers. The stronger version of equality of opportunity capability requires redistribution. So there's our tension. A government could argue, oh, it says equality of opportunity. We used to have. I wish I had the picture here. It's a lovely picture of an individual in a wheelchair looking up at a staircase with this sign. Oh, and in it, underneath it in French, it says, "You either have to resign yourself to this, or use genetic manipulation to change," and it goes on. It's an awful piece of advertising. But the point is that individual in a wheelchair treated unequally from the point of view of equality of opportunity? No. He has the opportunity to go up the stairs. He just simply can't do it. There's no law that says, you cannot go upstairs. That, if there were a law, equality of opportunity in the weak sense would say, get rid of that law. Because that law is a barrier. You can't go upstairs, but that's your problem. So it's absolutely crucial how equality is understood. You can't avoid it. You can't avoid this problem because the word equality does not have its definition written on its face, on its forehead, that you can say, oh, equality means, because it is a politically negotiable term. It is a value, and it does have its contours. You can make sense of it, but you have to do it argumentatively. You have to make the case that equality of opportunity is the robust version I'm thinking of and not the weak one. Okay, human rights approach. What is the human rights approach? We hear it all the time, and just as a public service, I would like to say sometimes advocates use phrases, we have to have the human rights approach. We went from the medical model, the charity model, to the human rights approach. And everyone is supposed to say, yay, we did it. What the did we do by doing that? Oh, I don't know, but we have the human rights approach. So as a public service, I'm going to tell you what the human rights approach is, because there is such a thing as the human rights approach. It's not a political slogan. Well, it is a political slogan, but it also has meaning. It may not be exactly the meaning you had in mind. I think it's the meaning you had in mind, but I don't think it's the meaning many people had in mind. So let me give it to you. Whatever human rights approach means, it has to be more than rhetoric. It has to be implemented and monitored. That's what the human rights approach creates. It creates an obligation to do something that can be monitored. Now this bunch of text comes from two authors which are on the bottom there. You probably can't see it because of Urban Johnson. And I'm going to make life easy by just extracting and highlighting, making it more transparent. The human rights approach to a document means that it is governed by human rights. That's trivial. But the responsibility is governmental. The human rights approach places primary responsibility on the government, something which may not be as in the front of one's mind when one thinks of the human rights approach. It is a legal obligation and moral duty. It is not based on charity and beneficence. Well, that's certainly what most of us had in mind with that phrase. It is transparent. The human rights approach states what it is on its face. And it requires, by virtue of that, full participation of the affected group, in this case, people with disabilities. Governments are responsible for both outcomes and process. So the human rights approach is both outcomes-oriented and process-oriented. A very crucial thing for Chairman Quinn's theory of change. The theory of change is a process mechanism. The outcomes are there to be monitored to see if the process works, but the procedural revolution in the theory of change is what makes the convention transformative. It doesn't say, wouldn't it be lovely if people were equal? Wouldn't it be wonderful if people had respect? Thank you very much. It says that and then says, moreover, in the triad that Chairman Quinn tells us about, moreover, it is something that you are held accountable for, and if you fail, you have to do it better. Without the process, without the procedure, without the mechanism, without the focal point, without the monitoring, it is hot air to have rights. There's a lovely book by a gentleman, last name Cohen, and I can't remember the title of it, of course, I'm getting too old for that, but it essentially says to put your faith in words like dignity is the most foolish thing to do as an advocate. Imagine a politician being required to fulfill the obligation of dignity. His speech would go like this: friends, I hereby recognize and respect your dignity. Thank you very much. Thank you very much. Thank you. Not one penny is spent to acknowledge dignity. That's the problem. Without redistribution, without a mechanism for securing and implementing and monitoring outcomes, you have no transformation at all. Another feature of this, which is very important and was mentioned by Jer, it is a systemic change. For too long, people with disabilities have been ad hoc, minister without portfolioed. They have been added on. We have this process. Let's put it this. That is what's wrong with disability policy. That it's not integral, it is not universal, it is not designed in a way which integrates it completely with the policy of the rest of the country for everyone. And that is what the human rights approach means, that rights are systemic. The human rights approach is not political rhetoric, but concrete change that directly benefits. So folks, that's the human rights approach. The next time an advocate says, but we insist on the human rights approach, whether they mean it or not, that's what they should mean by the human rights approach. It has content, the human rights approach, and that's it. It commits us to certain things. Essentially, it commits us to the government being on the hook and to do things in a transparent, participatory, accountable, systemic, and concrete manner. This is the package, as I would display it, of the human rights approach. Okay, we don't have time for that. What I want to do as attention is to say, what's an alternative? Well, another alternative is the so-called basic needs approach. People have needs, we satisfy their needs. Another very dominant approach to dealing with disadvantage, if you like. The basic need approach does not recognize rights, does not recognize entitlements. It is based fundamentally on philanthropic and charitable understanding that people in need, see if I can go back, people in need have certain needs which are prioritized and then responded to. It's a benevolent approach. It's not particularly bad, but it's based on the notion that concrete needs have to be met without the overlay of human rights. So it is an outcome generated approach that doesn't have human rights. The conundrum, the problem we have in policy is the basic needs approach is understandable, and economists can make sense of it and work it through without any hesitation, because these human rights sort of get in the way. Entitlements cause problems. So what happens if it is possible to actually meet needs of people without calling them human rights, without making them entitlements? This is a conundrum. The human rights approach would reject a policy that satisfactorily met needs if it did not make it a matter of rights. So outcomes do not satisfy the human rights approach. Something which is rarely brought out, but the logic of it is impeccable. The human rights approach insists that needs are met not charitably, but by entitlement. You are owed this. Now, what happens if in a country you can actually meet the needs? So no one is without assistive technology, no one is without education, no one is without anything they need. The only difference is you don't have a right to it. Well, it would be rejected on the human rights account. Now, maybe this is a quirk, maybe this is something which we say, well, it's not going to happen anyway, so why is this a theoretical problem? But keep in mind the human rights approach insists that there be rights. Not that there necessarily be outcomes, but there be rights to them. It recalls to mind when I was a lawyer, and one of my clients was fired because he had a missing part of his arm, and he was a nurse, and he couldn't do the job. And I was making this case as a young lawyer on the Ontario Human Rights Act, saying, get you back into a job, and because you have a right to a job. I said, you have a right. He said, I don't want a fucking right to a job. I want a job. And that stuck with me, because the point of the human rights approach is a job, but also an entitlement to a job. And one of the conflicting features of the human rights approach is having the job ain't enough. And that may be, maybe not, a worry. Okay, my last, before I get to the paradigm shift, is the universalism. I want to insist that the word universal must be taken seriously. We're talking about a human rights approach, and a human rights approach applies to human beings to core, without qualification. That's what I mean by universalism. Rights are applicable to everyone, without exception, modification, adjustment, blah, blah, blah. That's what a human right is. It's a right, the only qualification for which is your humanity. That's a human right. There are legal rights in which you have to have certain preconditions. Well, they're not like that. These are human rights. Now, the preamble of the convention speaks in this language. All members of the human family. Everyone is entitled, reaffirming the universality. So universalism is not something I'm inventing. It is imprinted into the very soul of this document. Universalism causes two problems that are not unreal, are not created for practice, but are dramatically difficult to solve. Does universalism conflict with respect for cultural differences? In Canada, my country, when 1981, the convention on, sorry, not the convention, the rights and the Charter on Rights and Freedoms, I've been away from my country too long, the Charter of Rights and Freedoms, one of the first groups that had within it equality of gender, one of the first groups that objected were the Inuit in northern Canada, who said, excuse me, in our culture, women are inferior. That's our culture. Who in the hell do you think you are to tell us, with your human rights, that our culture is wrong? Pierre Elliott Trudeau said, we're right and you're wrong. To hell with your culture. This is a Québécois, which is an interest in, if you knew the dynamics of Canadian politics, it's a funny thing to say. But Trudeau said, violating human rights takes precedence over respecting cultural differences. Well, this is a worry. This is a worry because it invokes the potential of colonialism, if you're thinking about it, or imperialism. And it has been argued, Universal human rights, well, that's a Western idea. That's a Western idea that is intended to apply to us in different parts of the world, and we don't think that way here. Now, universalism, there are two accounts, and the second of it you'll be spending most of this week on, so I'm not going to spend much time at all. There are two approaches to rights that are universal. One might be called absolutism. Rights trump, they overcome, they are more powerful than anything else. I don't even want to listen to you. Change your culture, bingo. A blunt and pretty useless, and certainly not, it won't win you too many friends either, I might add. Progressive realization, or progressive actualization goes by, there are different versions of it and different manifestations of it. I'm talking about the cultural one. Namely, the point is, you put rights on the political agenda, you implement them in a way which is respectful but persistent, if you like. You progress through the implementation of a right. You don't come down hard and say, in your culture, no gender equality, well, tough, we're going to bring in the troops and enforce this universal right of equality. No, you do it in a way which is respectful but persistent. And my understanding of progressive realization is that it's progressive. That is to say, you don't plateau. Well, we're going to go that far. You can disrespect the women, but you have to have these laws. Okay? Is that okay? Everyone happy? No, it is progressive. You start someplace only to move to a higher level. That is my understanding. That is my understanding of progressive realization, and that's, as you will see, is an interesting topic for discussion. You can respect cultural difference in two ways as well. Cultural relativity is the view that everyone's right. So, in their world, women are inferior. In our world, they're not. Everyone's right. Cultural relativity is the view which in the first year of a philosophy course is destroyed within 18 minutes by record. I mean, you could do it sometimes faster than that. It is the most ridiculous view that has ever been held, except by anthropologists. But there's a reason for that. Because relativism says not only are they right and everyone's right, but you can't even understand what they're saying. For them, women are inferior, but don't even try to understand it, because in their world, that's true. In your world, that's false. And there's no way, well, that's, obviously, universalism says, la condition humaine. There's the human condition. We all, as Shylock said, you cut me, I bleed. We all share humanity. We have variations of it. We try our best to understand the universe. We try to understand death. We try to understand pain. We do it differently, but we're human underneath it all. That's what universalism says. Cultural relativity says there is no human. It is just opinion. Well, there's something else that respects difference, and that is sensitivity, I'm calling it here. It's nothing original. Namely, cultural, linguistic, political, environmental differences, you have to make sense of them to implement things. You can't rush into the implementation of a convention or anything else without understanding linguistic differences, without understanding cultural differences. So that is a tool of implementation that is crucial to understanding how to get this human right worth something. Well, as it happens, universal human rights are completely incompatible with cultural relativity. You can't have both. You simply cannot have both. But you could be sensitive to the situation that you find yourself in, so they're completely compatible. So the first tension between universalism and something else is the tension between respecting cultural differences or respecting differences in general and being universal about human rights. The bottom line is human rights do trump because we're human at the end of the day. And there's no such thing as incommensurable differences. Differences that you can't even communicate between people. In time, patience, good faith, everything can be expressed everywhere. Remember, what am I? Idealist? Remember? Idealist? That is my faith. Here's the second one. Universalism and practical implementation. Is there a conflict between the two? Well, here I want to end with something which is a part of the convention and underlying it, but never expressed. There are always going to be priority problems or prioritizing problems. The implementation of a convention requires, I don't want to say compromise because that's not the right word,